Intellectual property, an introduction. Each form of intellectual property, and that's patents, trade secrets, trademarks, copyrights, are all important tools used for the protection of personal, private, and commercial information. Patents provide exclusive rights to new inventions, encouraging investment in research and development. Trade secrets protect valuable business information that gives companies a competitive edge. Trademarks safeguard brand identity, ensuring that consumers can distinguish between different products and services. Copyrights protect original works of authorship, securing the creator's rights to control and profit from their creations. Understanding these concepts is essential for businesses to navigate the complex landscape of intellectual property in their careers. For instance, a business strategy that includes securing patents and trademarks can significantly enhance a company's market position and value. Similarly, maintaining trade secrets and respecting copyright laws are crucial for legal compliance and ethical business practices. Intellectual property. Patents. A patent is a legal right granted by the government to an inventor, giving them exclusive rights to make, use, and sell their invention for a certain period of time, typically 20 years from the filing date. This protection encourages innovation by allowing inventors to potentially recoup the costs of research and development. For example, consider a tech startup that develops a new type of energy-efficient battery. By obtaining a patent, the startup can prevent competitors from manufacturing and selling the same battery, thus gaining a competitive edge in the market. The patent also adds value to the company, making it more attractive to investors. To be patentable, an invention must be novel, non-obvious, and useful. For instance, Apple's patent for the multi-touch screen technology used in its iPhones was a groundbreaking innovation that met all these criteria, enabling Apple to dominate the smartphone market. Intellectual property and trade secrets. Trade secrets are a type of intellectual property that consists of formulas, practices, designs, instruments, or processes. They provide a business with a competitive advantage. Unlike patents, trade secrets are not registered with the government. Instead, their protection depends on maintaining their secrecy. A classic example of a trade secret is the recipe for Coca-Cola. The company has kept its formula secret for over a century, giving it a unique market position. Coca-Cola employs strict security measures, including limiting access to the recipe to a few trusted employees, and not disclosing it in its entirety to any single person. Trade secrets can be anything from manufacturing processes to customer lists. For instance, Google's search algorithm is a closely guarded trade secret. This secrecy ensures that competitors cannot replicate Google's search results, maintaining its dominance in the search engine market. Intellectual property, trademarks. Trademarks are distinctive signs, logos, or expressions that identify products or services of a particular source from those of others. Trademarks are crucial for branding and can be registered with the appropriate government authority, such as the US Patent and Trademarks Office. For example, the Nike logo and the phrase "Just Do It" are trademarks that instantly convey the brand's identity and values. These trademarks protect Nike's brand from being used by others, ensuring that consumers can identify authentic Nike products. Trademarks are not limited to logos or just phrases. They can also include shapes, colors, and even sounds. For instance, the distinctive shape of the Coca-Cola bottle and the sound of the MGM Lion's roar are both protected trademarks. These elements are critical for brand recognition and consumer loyalty. Intellectual property and copyrights. These protect original works of authorship, such as literature, music, films, and software. The protection grants the creator exclusive rights to use and distribute their work, typically for the creator's lifetime plus an additional 70 years. An example is J.K. Rowling's Harry Potter series. Rowling holds the copyright to her books, allowing her to control their publication and adaptation into movies and merchandise. Unauthorized reproduction or distribution of her work would constitute a copyright infringement. Copyright protection also extends to software. For instance, Microsoft holds the copyright to its Windows operating system, preventing others from copying or distributing the software without its permission. This protection is vital for software companies to secure their intellectual property and revenue streams.